January 20th, 2026. The Supreme Court will hear a case that gun owners are calling the most important carry case since Bruen. But here's what nobody is talking about. Hawaii just filed a brief making an argument that could reshape how we think about the Second Amendment. They're not saying guns are dangerous. They're not citing crime statistics. They're making a property rights argument. Hawaii says, business owners have the right to exclude anyone from their property, including armed customers. Our law doesn't ban carry. It just requires permission first. And that argument is brilliant, because it forces the Supreme Court to answer a question they've never addressed. When you walk into Walmart with your concealed carry permit, whose rights matter more, your Second Amendment right to carry, or the property owner's right to exclude you? The Trump DOJ and 26 states say Hawaii's law is unconstitutional suppression of gun rights. But Hawaii is betting the Supreme Court will side with property owners. Let me show you exactly how Hawaii is defending this law, and why their strategy might actually work. First, let's understand what Hawaii's law actually does, because the headlines get this wrong. Hawaii Act 52, passed in June 2023, created a default rule for carrying firearms on private property open to the public. Old rule, pre-Hawaii law. You can carry your gun into stores, restaurants, gas stations, unless the property owner posts a no-gun sign or verbally tells you to leave. New rule, Hawaii Act 52. You cannot carry your gun into a NY private business. ANLES. The owner gives you express permission, verbal or written, or the business posts a sign saying guns allowed. It's a complete flip. Default went from allowed unless prohibited to prohibited unless permitted. According to court documents, this law makes 96.4% of land in Maui County. OFF limits for a concealed carry. Gun owners call it the vampire rule, like vampires can't enter without permission. Neither can your firearm. Christopher Wolford, a Hawaii resident with a concealed carry permit, challenged the law. He argued, "You gave me a permit but made it useless. I can't carry anywhere I actually go in daily life, gas stations, grocery stores, restaurants." He sued. And that lawsuit became Wolford v. Lopez. Now here's where Hawaii's defense gets smart. They're not arguing that guns are too dangerous or that AR-15s are military weapons. They're arguing property rights. Hawaii's brief to the Supreme Court makes three main arguments. Argument number one. The Second Amendment never protected armed trespass. Hawaii argues, the Constitution has never protected a right to armed entry without a property owner's permission. They cite English common law going back to the 1600s. Property owners have always had the right to exclude unwanted visitors, including armed ones. The brief states, since the founding, the right to exclude has been a core feature of property ownership. Nothing in the Second Amendment overrides that principle. Hawaii says, when you enter private property, you're there by implied license. The owner implicitly permits you to enter for the purpose of doing business. But that implied license doesn't automatically include bringing weapons. Argument. #2. Historical tradition supports consent requirements. Hawaii cites founding-era laws that prohibited carrying weapons in specific private locations without consent. 18th century laws against bringing weapons to houses of worship without permission. 19th century laws requiring consent to carry in theaters and assembly halls. Historical prohibitions on armed entry onto another's land without permission. Hawaii argues, there is a historical tradition of requiring consent before bringing firearms onto private property. Our law fits that tradition. Argument number 3. Our law doesn't ban carry, it just requires permission. This is Hawaii's most clever argument. They say, we're not banning carry. We're clarifying who has the authority to permit it, the property owner, not the government. Hawaii claims their law expands property rights by giving owners more control over who brings weapons onto their premises. The brief states, businesses open to the public still retain the right to exclude firearms. The state is merely clarifying that the implied license to enter does not automatically include bringing a gun, But the Trump Department of Justice filed a 43-page brief destroying Hawaii's property rights argument. The DOJ makes 4 counter-arguments. Doge counter number 1. Hawaii's law was designed to suppress carry, the DOJ argues. Hawaii's law isn't about property rights. It's about making concealed carry impossible. The brief cites legislative history showing Hawaii's intent was to frustrate the Bruen decision, not protect property owners, DOJ writes. Hawaii designed its affirmative consent rule to inhibit the exercise of the right to bear arms. The ultimate goal is to expand gun-free zones across the state. Doge counter number 2. Property owners already had protection. The DOJ points out, Hawaii already has trespass laws. Property owners can already kick out armed customers. They can post no gun signs. Hawaii's law is unnecessary if the goal is truly protecting property rights, the brief argues. The traditional presumption carry allowed unless posted already respects property owner autonomy. Doge counter number 3. The law discriminates against firearms. The DOJ brief makes a brilliant point. You don't need permission to bring bicycles, roller skates, muddy shoes, or dripping umbrellas into stores. But guns require express authorization? That's discriminatory treatment of a constitutional right. Doge counter number 4. No historical precedent for default BA. The Doge argues that while some founding-era laws required consent for carry in specific sensitive places, churches, courthouses, there was nitrogen monoxide tradition of a blanket default ban on a LL private property. Hawaii's law isn't a narrow restriction on sensitive places. It's a statewide ban on public carry, with rare exceptions, that has nitrogen monoxide historical analog, the DOJ concludes. And here's the bombshell. The DOJ asked the Supreme Court for permission to participate. In oral arguments on January 20th, they want to argue alongside gun owners against Hawaii. That means the federal government will stand in the Supreme Court and say, state gun restrictions violate the Second Amendment. But it's not just the Trump Doge. 26 states filed an amicus brief supporting gun owners. These states argue. Courts across the country continue to defer to legislative judgments regarding firearms regulations, despite Bruen's declaration that judicial deference to legislative interest balancing is not what the Second Amendment demands. The 26 states include Alabama, Alaska, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, and Wyoming. They argue Hawaii has turned carry rights into a charade and a child's game of mother or may. The brief states, rather than presuming that public carry was permissible unless expressly forbidden, public carry is now presumptively forbidden in Hawaii unless expressly permitted. They urged the Supreme Court to reverse the Ninth Circuit and strike down Hawaii's law. Here's why the Supreme Court had to take this case. Federal circuits can't agree. Ninth Circuit, Hawaii, California, upheld Hawaii's law, said it's consistent with property rights and Second Amendment. Second Circuit, New York, struck down similar New York law. Side default ban violates Bruen. Third Circuit, New Jersey, struck down parts of New Jersey's similar law in Coons v. Bruck, October 2025. That's a circuit split. When circuits disagree on constitutional questions, the Supreme Court steps in. The question they'll answer: may Hawaii presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission? January 20th, 2026, oral arguments. Here's what I predict will happen. Hawaii's attorney will argue, this case is about property rights, not gun rights. Business owners have the right to exclude armed customers. Our law clarifies that right. We're not banning carry, we're empowering property owners. Tough questions Hawaii will face. Justice Thomas, likely. Counsel. You cite historical laws requiring consent in churches and courthouses. But those were specific sensitive places. Your law applies to every business. Where's the historical analog for that? Justice Kavanaugh, likely. If your law is about property rights, why does it require consent rather than allowing owners to post signs? The historical presumption was allowed unless posted, wasn't it? Justice Barrett, likely. You say this isn't a ban, but if 96% of land is off limits without express permission, how is that not a functional ban? Trump Doge attorney, if allowed to participate, will argue Hawaii's law was designed to make the Bruen decision meaningless. They call it property rights, but it's really about suppressing Second Amendment rights. The historical default was carry allowed unless owner objects, not carry banned unless owner permits. Gun owners. Attorney will argue, Hawaii gave me a concealed carry permit and then made it useless. I can't carry at gas stations, grocery stores, or restaurants without hunting for a guns allowed sign. That's not a licensing system, it's a ban with rare exceptions. Prediction: Hawaii will struggle. The conservative majority, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, Roberts, will likely side with gun owners. Decision: 6-3 or 5-4 striking down Hawaii's law. If the Supreme Court strikes down Hawaii's law, 5 states are immediately affected. Hawaii to 96.4% of Maui land becomes carry-friendly California. Similar law would fall New York. Attempted similar restrictions post-Bruen New Jersey, already partially struck down by 3rd Circuit. Maryland has considered similar approach that's millions of gun owners getting their carry rights. BACK. But if Hawaii wins, every blue state will adopt this property rights approach. They'll flip the default and make carry nearly impossible without giving away permits. Gun Owners of America warns, if Hawaii wins, expect California, Massachusetts, Connecticut, and others to pass identical laws. Concealed carry will be functionally DEAD in blue states. Action number 1. Watch January 20th oral ARGUMA test. Supreme Court will live stream audio. Listen to how justices react to Hawaii's arguments. Their questions reveal how they'll vote. Action number 2. Prepare for June de Session Supreme. Court typically releases controversial decisions in June. Expect Wolford ruling. June 2026. Action number 3. KNOW. Your state's law and NOW if you live in high CANYNJ. Or MD. Follow current law until Supreme Court rules. Don't test the system. Action number 4. Support organizations FIJCNG Second Amendment Foundation, Firearms Policy Coalition, NRA. They're funding this litigation. Even $10 a month helps. Action number 5. Understand the stakes. This isn't just about carry permits. It's about whether states can use property rights as a backdoor to ban guns. If Hawaii wins, expect more states adopting similar laws. Functional end of public carry in blue states. Years more litigation if gun owners win. Expect 5 states' laws to fall. Default returns to carry allowed unless posted. Major Second Amendment victory. January 20th, 2026 is the most important day for concealed carry rights since Bruen was decided in 22-2. Hawaii is making a smart argument: property rights instead of public safety. They're betting the Supreme Court will respect property owner autonomy over gun owner rights. But the Trump DOJ, 26 states and gun rights organizations are calling this what it really is: a backdoor ban designed to make Bruen meaningless. The Supreme Court will decide. Do property owners have the right to require permission before allowing guns? Or does the Second Amendment guarantee a default right to carry unless property owners object? That's the fight. And it will reshape concealed carry laws across America. Subscribe and turn on notifications. I'll cover the oral arguments live on January 20th and break down the June decision when it drops. Comment below. Do you think Hawaii's property rights argument will work? Or will the Supreme Court side with gun owners? Share with every concealed carry holder. This decision affects millions. The battle begins January 20th, and the future of public carry hangs in the balance.